Well, good afternoon, everybody. I'd like to welcome you to today's WRRC Water Webinar titled An Overview and Update on Arizona's General Stream Adjudications. We really welcome you. It looks like we've got a good turnout for today's talk. Just a few items to go over. I am Sharon Megdal. I'm Director of the Water Resources Research Center. I ask that you please keep yourselves muted through the webinar. The presentation will be followed by Q&A. Jennifer Wendel, our speaker, expects to talk for close to 50 minutes, but we will have time for Q&A. We ask that you put your questions in the chat, and we go till 15 minutes after the hour. So we should start a few questions before the top of the hour, but we'll go as late as 15 minutes after the hour. This will be recorded, and the slides and the recording will be posted to our website. Usually within a day or so. It might take a little bit longer this time just due to people's schedules, but it should be posted by, what is today, Tuesday, Thursday at the latest. I would like to respectfully acknowledge that the University of Arizona is on the land and territories of Indigenous peoples. Today, Arizona is home to 22 federally recognized tribes, with Tucson being home to the O'odham and the Yaqui. The university strives to build sustainable relationships with sovereign Native nations and Indigenous communities through educational offerings, partnerships, and community service. I would like to bring your attention to the items noted on the slide up on the screen now about some of our upcoming events. We have a Native Voices in STEM seminar coming up on September 17th. It's the first in that series by Michael Johnson, and that should be great. On the 18th, if anybody happens to be up in Phoenix and would like to come over to the University of Arizona Scottsdale Center, I'll be giving a chat there, Dry Times, Bold Moves, and Innovation. And then on the 26th, we have a co-hosted event with the Udall Center for Studies in Public Policy. Brad Udall will be on campus at ENR2 and is talking about Dancing with Deadpool. So that's an intriguing title. And then our next regular water webinar will be on October 6th, and we'll be talking about the Internet of Water. We had a webinar on that some years ago, and we're going to get an update on that. And then we are hosting Arizona Water Company to talk about their sustainable water resources strategy, and we'll have their president and their vice president for water resources. And then please save the date. As noted here, the annual conference will be April 14, 15, 2026. And we're just this week announcing the title of, we're going to be looking at commercial and industrial water stewardship, looking at some of the large non-agricultural water users. As always, we invite you to keep up with our activities and other water news through subscribing to the Weekly Wave, and our events page lists these and other events. So with that, again, I'd like to welcome you and thank you all for being here with us today. And it's my pleasure to introduce Jennifer Wendel. Jennifer manages the Arizona Adjudications project within the Natural Resource Use and Management Clinic at the University of Arizona College of Law. Before joining the clinic, she worked as an attorney advisor for the Office of the Solicitor, Department of Interior, representing agencies like the Bureau of Indian Affairs, the Bureau of Land Management, and the National Park Service in land, environmental, and water matters. Prior to that, Wendel worked for the Idaho Attorney General's office, representing the Idaho Department of Water Resources in the state's general stream adjudications. And Jennifer, we're really delighted to welcome you today to enlighten us. Many of us in the audience, I'm sure, are not attorneys, and we hear about the adjudications process, but don't really understand what it's all about or want to know more, and particularly what your program is doing. So Jennifer, thank you for being with us, and I'll turn it over to you.
Thanks very much, Sharon, and thanks everyone at the WRRC for hosting me today, and also just for making the U of A a great place to work on water issues. So I'm going to go ahead and share my screen here. All right, you should be seeing my presentation now.
And we are. Looks
Excellent.
good.
So again, I'm Jennifer Wendel. I am an attorney with the Natural Resource Use and Management Clinic at the university here. I work at the College of Law. The clinic is a clinic for all different types of natural resource issues. So students take a class component with the clinic, and then they also get to take on their first real clients as part of our clinic work. And I specifically run a project within the clinic called the Arizona Adjudications Project, where we represent folks who have smaller water rights claims in the general stream adjudications, folks who need to figure out if they have surface water rights, if they've filed their adjudication claims correctly, and then we also represent them in front of the special master just until they settle out their water rights. So today I'm going to talk to you about our two general stream adjudications in Arizona. And before we really get into it, I'm going to give a big history on why we have general stream adjudications, because it's not intuitive. So we have two general stream adjudications in Arizona here. We have the Little Colorado River Adjudication and the Gila River Adjudication. And you can kind of see why those colored areas are shaped that way. It's the entire watershed with all the major tributaries that come off of those two rivers. Notably on this slide, you'll see that the other main river here, the Colorado River, is not part of the adjudication here. And that's something a lot of people don't know about. If you have any water rights on the Colorado River, they're either already decreed or they are through the federal government, because that's a Bureau of Reclamation project. So that is not part of the general stream adjudications at all. It's only the Little Colorado River and the Gila River adjudication. And to kind of understand what this is and why we have this going on, we're going to talk a little bit about the history. So I have kind of two main things to talk about today. The first is the origin of stream adjudications, to talk about prior appropriation and the foundation of Western water law, early water rights in Arizona, and then why do we need general stream adjudications. And then we'll get into the actual kind of nitty gritty about the current adjudications and talk about the two stream adjudications going on in Arizona, what's happening with them, and then what are some of the current issues in those adjudications. So first, we always have to talk about riparian water rights. So when the United States was first founded, we were all on the East Coast, and they brought over common law from England, and that was riparian water rights. And that's because folks live next to streams to use water. That's just where water was used. Riparian rights meant that you had the right to reasonable use of water as it flows along your property, and you have to share equitably in all the shortages. So you didn't own a quantity of water, you had an equal share of water along with all the other riparian users around you. The limits on that were that you could only use the water that bordered your land. So you can't take water from somewhere else and move it onto your land. And then you also can't harm neighbors. So you can't degrade the quality or quantity. So everybody takes those equal shares, cuts in water rights. In the West, at that time, we had other types of water laws that were already in place. We had a lot of folks living in the United States before it became the United States. And here in Tucson, we have Mission Garden that's recognized as one of the oldest continually cultivated agricultural sites in North America that dates back about 4,000 years. And it has some of the oldest canal irrigation in the United States. So obviously there was a lot of water use already going on. Water was being managed in significant proportions here. And same for across the West. And I highlight some of the ancestral homelands of Indigenous folks in California, because California is where our Western water law developed. So when the United States purchased California and all of this territory in 1848 through the Treaty of Guadalupe Hidalgo, there was no United States citizens per se living in these lands. And so there was an immediate need of the federal government to want to try to bring people out to California. Obviously, there were a lot of people already living here, but they weren't who the United States deemed US citizens here. And at the same time, this was February 2nd, 1848, pretty much in the exact same month, the California gold rush started, and people started pouring into California, and they were doing this gold panning and figuring out that there was all kinds of good stuff in the mountains there. But very quickly, it went from this pretty quaint gold panning right off the river to really significant mining. And this was hydraulic mining. The water use was significant, and it was not right next to the stream. And so we couldn't apply riparian water rights to all of this mining that was happening in California. First, because the federal government owned the land at that point. There weren't many private landowners at all. And so riparian water rights, again, only attached to the land that you own. And so none of these folks using water actually owned a lot of the land. A lot of the water use was off stream. And so that doesn't apply to riparian water rights either. They were taking the water away from the stream and bringing it over to do this major hydraulic mining. And then also, there was a kind of concept of water law that developed to help substantiate all of the mining economic interests. So we had this kind of first in time, first in right, finders keepers kind of water law that developed that said, I was here first and started using water for this mining, so I get first cut to it. And the second person here gets second cut. And that's just kind of how the miners themselves worked out to use the water. And we had some federal state courts at those times, but they were pretty weak because there weren't many people in the United States, especially on the West Coast. So they just started kind of recognizing those communal laws that the miners were already putting in place. We talked about how there was already significant water use from indigenous folks in the area, so there were other ways to manage water. One other way was this more communal way called an acequia, that is from Spanish law, and these still exist in New Mexico and Colorado. And this is just to say that prior appropriation was not kind of the natural course of the way things had to develop, but that's just what we ended up using in the West. So the foundation of prior appropriation, people often cite this case, Irwin v. Phillips, and I won't read the whole thing here, but essentially it's two claims that are trying to fight in court about who has the first right. And the court essentially says, the person who's earlier in time is stronger in right. So put simply, first in time, first in right. And this is where we get our foundation of Western water law that pretty much most of the Western states use some form of. In Arizona, this is very much the foundation of our water law. And so what that means, first in time, first in right, it's literally just a list. We just say who is first, who is second, and then you give water in that order. So if there's only enough water to fill the first two water rights on the stream, the third person gets no water rights. And so this is kind of the standard graph image that's used to share this. If you have a junior user who's upstream of the senior user, and there's only sufficient water for the senior user can make a call on the river and say, junior user, you get no water till I get all of my water. And that's how prior appropriation works. So the elements of prior appropriation, you have to have intent and notice to appropriate water. And I have notice in parentheses because at different times, notice sometimes meant just you were actually appropriating it. And that means that water, it wasn't accidentally coming onto your land. You intentionally went out and diverted water and were putting it to a use. There has to be an actual diversion. So again, not some kind of accidental something on your land. You specifically intentionally went out and diverted water. And then you have to put the water to a beneficial use. And these are defined in statute and also case law. And the typical beneficial uses you'll see are domestic, stock, irrigation, wildlife, municipal, fish, recreation, water power, and non-recoverable storage. Importantly, the water right is appurtenant to or tied to the land on which it was developed. So if you start using water on one parcel and then 5 years later you say, well, actually, I'm going to use it over here, that's a different water right. The water right is tied to exactly where you first started using it. And water rights are usufruct. So you have the right to use the water subject to the laws that are regulating it. So you don't own the water, you own the right to use the water subject to the laws that are regulating it. So this is a map of the United States and all the different types of legal water rights regimes. So you can see on the East Coast, it's still mostly riparian. There's pure and regulated. Regulated just means you have to go get a permit from some kind of agency, but it's still riparian water law. Mostly on that west, right at that continental divide. On the west, we use prior appropriation. And then there's also a mixture. So California retains some kind of, it's called correlative water rights that are kind of like riparian water rights. And Nebraska and Oklahoma do too. And everybody else just uses pure prior appropriation here. So looking at water rights in Arizona then. So we're using prior appropriation in Arizona and want to start thinking about what were all the water rights that developed in Arizona. So first, obviously, there were Indian water rights. There were folks already living here before this was the United States, and they were using a lot of water. This is just a screenshot of, there's a kind of cool map online that shows you all the indigenous ancestral territories of different tribes. So this is what is Arizona. It's hard to tell, but just to say there are a lot of people already here. But that's not where the tribes live today. So this is a quote from John Thorson, our former special master of Arizona's general stream adjudications. The fundamental history of the Western region is one of massive land acquisitions and disposition, along with the involuntary relocation of native peoples to make way for Anglo-European adventurers and settlers. So there was a forceful removal of indigenous folks in Arizona onto what are now reservations. But we do still have 22 federally recognized tribes in Arizona with significant water rights, and they are a huge part of Arizona's water management today. And the reason they have water rights is this case that is called Winters versus United States, and you can spend a lot of time on some of this stuff, but we're going to kind of breeze through it. So in Winters, this is the Fort Belknap Reservation in Minnesota, and the tribe had the water in the river started drying up because farmers upstream were taking a lot of the water out of the river. And this case went to the Supreme Court, and the Supreme Court said, even though the reservation, the treaty, the reservation of this tribe did not specifically reserve water, obviously the point of the United States in putting these folks here was that they could live. And to live, you need water. And so we're going to imply that there was some kind of water that is necessary to be part of this reservation. And so the priority date of that water, because priority dates are really important in prior appropriation, you want to know who's first in time. The priority date for this reservation was the date of reservation. So the date the federal government reserved that land. This is a picture from, I borrowed this from Robin Interpreter, who's an attorney in Indian law in Phoenix. So this is all of the tribes with settlements in water rights settlements in Arizona. And then the ones without water rights settlements or partial water rights settlements. And highlighted right now, the Navajo Nation, the Hopi tribe, and the San Juan Southern Paiute tribe have a settlement that has been passed internally for the second time and is pending before Congress for funding. And the Yavapai Apache Nation also has a recent settlement that's also awaiting funding from Congress. So these tribes work with all of the parties in the adjudications. These are huge settlements. It takes decades to work on some of these. And everybody comes together and agrees on what the water rights will be for the tribe. And then it has to go to Congress. Once everyone's signed off here, it has to go to Congress, and Congress has to effectuate it by actually funding it. Because some of the funding goes to actually figuring out ways to put the water to use. So we have Indian reservations rights that exist in Arizona. The second type of rights that started existing were land patent settlements. So like we talked about earlier, there was a massive push to have people move west and start living out in the new territories of the United States. And one big push was the Homestead Act of 1862, where folks would get a huge tract of land to be able to put on a house, start farming and raise a family and homestead. There were, the Desert Lands Acts expanded that. In the West, you needed some more land because we had ranching going on out here. And so there was significant federal laws that were passed to make it easier for folks to come live in Arizona. And this is a graph of all of the homestead entry claims in Arizona over time. And you can see there's a lot, there's thousands of them. And these are old water rights. We also had significant mining going on in Arizona. The mining law of 1872 drove a lot of people to come prospect in the West. So we have some pretty large mines in Arizona today that really date back to this original mining law when people started discovering what was in Arizona. And then we also have federal water rights for non-Indian purposes. So there's several cases that define this. Capert is one of the big ones. This is Devil's Hole with the pup fish. And this is Devil's Hole is this, it's this tiny, it's in that picture right there. That's all the water that exists in Devil's Hole. And there's an endangered fish called the pupfish, and it only breeds on a specific shelf in this hole. And there has to be just the right amount of water because the temperature has to be right. And there was a ranch nearby that was pumping water and the level was decreasing. And so similar to Winters, the court said that even though there wasn't a specific amount of water reserved when the federal government created Devil's Hole and reserved it, the court read that there is water appropriated. The amount of water that's appropriated for Devil's Hole is the amount that's necessary to accomplish the purpose for which the reservation was created. And here, the purpose of the reservation was to preserve those fish. So they got this kind of weird quantity of water right. Federal water rights are a little different than state water rights. You get different kind of quantities with them. But pumping on the Capers Ranch had to be limited so that the mean water level didn't fall below 3 feet below the copper washer. So that meant that they retained the specific amount of water needed for those fish. So now we're adding on to the list again. We have non-Indian implied federal reserved water rights. And this exists in Arizona in a variety of places. One I'll just highlight is the San Pedro Riparian National Conservation Area. This one is a little interesting. This is the Enabling Act, and you see at the bottom here, it specifically says water rights. There's not a quantity reserve, but they did reserve some water rights. But most federal reservations don't have anything about water rights in there, and they just have to be read in. But to read into what was the intent of the federal government, they typically look to this establishment, the beginning of a reservation, in order to protect the riparian area, aquatic, wildlife, scientific, cultural, educational. So, you need specific amounts of water to protect aquatic, wildlife, all of that. Arizona has a lot of federal lands, and so it's much more than Sprinka that has these reserved federal water rights. There's a lot of major federal water rights across Arizona. And this is important because in 1952, Congress passed the McCarran Amendment that waived the United States' sovereign immunity for purposes of a general stream adjudication. So that meant that all of these federal claims that we didn't know about, they have to be litigated in state court. So the United States has to file their water rights claims in state court. So that kind of brings us into the list of all the state water rights that are going on. Even though they're federal and they have some different rules, they still have to go through state courts. So now we're also adding on one more. We have other water rights that were established via prior appropriation. So I highlight here the Salt River Project. This was partially a federal project. It was in conjunction with the Bureau of Reclamation, but they have state law-based claims. And Salt River Project up in Phoenix manages 7 major reservoirs across the Verde watershed, and they manage a huge amount of water. So there's a lot of water rights that existed there too. Then in 1919, Arizona said, like many other states said around this time, now if you want a surface water right, you can't just go out and start using it via prior appropriation. You have to go to what is now the Department of Water Resources and ask for a permit to use the surface water. And then when you get a permit, then you have a surface water right. All those water rights that existed pre-1919 that were started, they still were in existence. We just don't have any records of them. So we don't know necessarily who owns them. We don't know the quantities, and we don't know their priority dates, but they're all out there. But starting 1919, you had to go to what is now Department of Water Resources and get that permit. And so the water that you can appropriate through a permit is surface water. It's the water of all sources flowing in streams, canyons, ravines, or other natural channels, or indefinite underground channels, whether perennial or intermittent, flood, waste, or surplus water, and lakes, ponds, and springs on the surface. So adjudications, we're talking about surface water rights only. Appropriable water is not diffuse surface water. That's kind of like sheet flow from rain. It's not percolating groundwater. So there's water that is going straight down to an aquifer, and that's percolating groundwater, and that's different than surface water. And effluent is also not included in this. So now we also have certificated surface water rights on this list. So this is an application for permit to appropriate public water from the state of Arizona. This is the application you send to Department of Water Resources to go get a new surface water right. So you check your type of use and your purpose of use and the quantity you're using and everything. But I added 2 things on this slide. So we have certificated water rights, but that code was in 1919. So at this point, we also have a lot of old certificates that might not actually be current. So they might no longer exist. Someone might not be using the water anymore. Elements of that water right might be off. Someone might be using way less water. They might be using a different purpose for the water. So we don't know if all of those, older permits still look the same today. And then we add one more to this list. In Arizona, we make this really complicated and we bifurcate surface and groundwater. So in some other states, if you have a well that's near a river and it impacts the flow of that river, they just recognize that there's a connection there and then you kind of work that out ad hoc. In Arizona, we don't recognize that connection at all and say there's surface water and there's groundwater and there's nothing in between. But there really is something in between. So we've had to create an entire new category of water called subflow. So we're going to talk about this more, but for now, I'll just say that wells that are pumping surface water need a surface water right and are subject to the adjudication. So in this picture, there's a cone of depression here from a well, and that's that big circular thing. So as you pump, this cone of depression expands and gets larger and larger. And then you have water that gets drawn in. If it's close enough to a river, it's actually drawing in some of that surface water. So this pump would need a surface water right in Arizona. So then here's our full list. We have all kinds of water rights that exist in Arizona. Many of them we don't know the quantities for, and we don't know their priority dates. We don't know a lot about them. We have Indian water rights, land patent settlements, mining water rights, non-Indian federal water rights, other water rights established by prior appropriation, certificated water rights, and ones that are probably no longer accurate, wells in the subflow zone without a surface right. And then there's all kinds of other water uses that they're unpermitted. So there's probably a lot of water uses that started post-1919 that don't have a surface water right, but are using surface water. And again, the whole point of prior appropriation is you need that list and you need to see who's first in time. And so there's a lot we don't know about Arizona water rights. And we need to kind of, fill down that list. So with all of these claims, we need to have an adjudication. So this is a quote from Burke Griggs, who's a water law professor, kind of riffing on Pride and Prejudice here. It's a truth long acknowledged that a river basin possessed by too many claims must be in want of adjudication. The reason is simple, because you can't administer something you can't define. So we can't administer prior appropriation if we don't know what water rights exist. So a stream adjudication is just a snapshot in time of all the surface water rights that exist. This is a screenshot from the Department of Water Resources website that shows all of the claims in the adjudication. So there's a lot. And what we do is we say everybody who's using surface water right now has to file an adjudication claim, whether it was pre-1919, whether you just got a permit yesterday, we want you to file an adjudication claim. And the stream adjudication becomes this major court proceeding that inventories and catalogs surface water rights at that snapshot in time. The adjudication court will issue a decree that confirms the elements of each water right. So the elements are the owner, the point of diversion, the place of use, the quantity of use, things like that. So back to this picture here, we have two general stream adjudications in Arizona, the Little Colorado River Adjudication and the Gila River Adjudication. There are a lot of claims in these, and these numbers aren't accurate because they are always growing. So we have more than 3,100 parties in the LCR Colorado River Adjudication with more than 11,000 claims, and more than 24,000 parties in the Gila River Adjudication with more than 66,000 claims. So there's a lot of people. These are the largest court cases that exist. So these two adjudications were both started late 70s. SRP started the Gila River Adjudication, and the Phelps Dodge started the Little Colorado River Adjudication. Essentially, they were trying to figure out their own water rights, and parties just kept joining, and it grew and grew. And so then they became what's now known as a general stream adjudication, which includes all the water rights on a system. And it has to be a general stream adjudication for purposes of that McCarran Amendment that brings the federal government into state court. So all the water rights have to be included. So we go through an adjudication court. States do it a little bit differently. We kind of have this hybrid approach where you both file claims with Department of Water Resources, and then they go through the adjudication court in Arizona. So the court is the location where the most amount of claims are located within each adjudication. So in the Gila River Adjudication, it's the Maricopa County Superior Court, and the Little Colorado River Adjudication, it's Apache County Superior Court. It's a little confusing because both of those end up just going to the same people. We have one judge assigned to adjudications in Arizona who sits in the Maricopa County Superior Court. That's Judge Blaney. The judges rotate, so he just rotated on about 2 or 3 years ago. And then we have a special master who oversees the day-to-day cases, and that's Special Master Zendri, who's actually a U of A law alum. We just hosted her here about a week and a half ago to talk to the students. The special master oversees all the contested cases, so she's doing a lot of the day-to-day work in the adjudication, and then makes recommendations to Judge Blaney. So appeals go up to Judge Blaney. And the reason we have a special master, I'll note too, adjudications are very complicated, and you need some knowledge of water. So Special Master Zendri comes with a lot of that background knowledge. So now I'm just going to go over big picture. What is an adjudication? So the first thing you do in an adjudication is you file claims. This is an example of a new use summons. I think this is how a lot of folks are finding out about the adjudications today. You get kind of a scary notice from the court that says you may or may not be in the adjudication, and if you don't file a claim, you're going to lose your water rights. But the other way that folks are a part of the adjudications is that they previously filed some kind of adjudication claim. So an adjudication claim is called a statement of claimant, or a 39 form, and that's 39 because that's the number, the prefix on these forms. And what you do is you claim your legal basis of right. So you have to have a legal basis to your surface water right. You claim that in the adjudication, and then it proceeds to the adjudication court. And the two main ones that we look at, I don't think my clicker appears on screen here, but it's this A and B. It's typically either pre-1919 water rights, so water rights that existed before that water code, or post-1919 water rights that have some kind of permit. So there's other ways to get water rights in Arizona. This is by far the most common two ways that you will have a surface water right in Arizona. First is that post-1919, you got a certificate from the Department of Water Resources. And if you don't have a certificate, then you maybe went and applied for a certificate from the Department of Water Resources. Or pre-1919, you filed what's called a statement of claim, which is very confusing because a statement of claim is not the same as a statement of claimant, which is an adjudication claim. Very poorly named. But for pre-1919, you file a statement of claim, and then you submit all kinds of proof showing that you had pre-1919 water rights. So typically that involves submitting a homestead patent and land entry case files to show what the original water use was. And then you track the water use over time too, and show that the water continued to be used on that parcel for the same purpose. Oh, this got cut off a little here, but the priority date of a pre-1919 use is the date of first use, or the date the right was noticed. So that's your priority date for the prior appropriation purposes. For a post-1919 use, the priority date is the date you filed for your water right, not the date of first use. So if you found out today that you need to have a surface water right, even though you've been using water since the 80s, your priority date will be 2025. If you have a small domestic claim, it's a little less difficult. You can still move through the process, but that can be difficult for a lot of people to understand. And also importantly, you can lose your water right. So we have two main ways to lose a water right in Arizona. There's forfeiture and abandonment. Forfeiture is statutory. It means 5 years of non-use. So if you don't use your water right for 5 years, you automatically lose it. That's just it. That's the statute. Abandonment is this common law concept that was then codified in our laws, and there has to be an intent to abandon. And so it's not 5 years automatic non-use. It can be 1 year, but you took out your well, and it shows that you clearly don't intend to use that water right anymore. So it's a fact-specific inquiry. But just going back to that last slide, if you had an older water right and it hasn't been used for a very long time, it might have been forfeited or abandoned. So that's something to consider. So here's the second step, and how do adjudications actually work? Everybody filed their claims. The next step here is that DWR goes out, the Department of Water Resources goes out and reviews all of those claims in what's called a hydrographic survey report. There's a lot of terminology in adjudications. And what they come up with is these individual watershed file reports that are within a hydrographic survey report. And we've got thousands of pages here. And they look at every individual claim, and they look at what did you file? What was the legal basis of filing? Is that water actually being used? And then they recommend to the adjudication court what the water right should be based on what was filed and what they see actually being used. The next step is that both Department of Water Resources, the court, and all the parties determine what the subflow zone is. They have to figure out which water rights are subject to the adjudication. We're going to talk about subflow next, but big picture, it just means some wells, even though they're pumping water that is from the ground, they're actually pumping surface water, and they are subject to the adjudication because they're close enough to the streams such that their well impacts the stream and they're pumping that surface water. So you have to figure out before we move forward with the adjudications, which wells are subject to the adjudications. So DWR makes these reports, and here's a sample of one of them. This is the lower Little Colorado River subflow report that just came out about a week ago from the Department of Water Resources. I guess importantly too, I'll say here for subflow, there's 2 steps to this. DWR issues a report and then the court issues an order on this. So these steps take a very long time, which is why we're 51 years into the adjudications and we're still doing this presentation. So then there's a de minimis determination. There's a whole kind of group of water rights that are so small that courts say we shouldn't trifle with them because they're just too small to have to go through individually. It doesn't make sense to spend a lot of time figuring out exactly how much water is being used in this small domestic well versus all of the other major water rights. And this is a determination that's made per watershed because if it's too small, it's relative to all the other water rights that are going on in that watershed. So DWR does a full review of all of the water uses in the watershed and comes up with a report to the special master, and then the special master ultimately issues an order saying this is the de minimis determination. So in the San Pedro watershed, domestic de minimis right is 1 acre-foot or less. And this is the same thing as the subflow report. First, you have a report from the Department of Water Resources, and then the court issues its order on that. And so finally, once all those big picture things, those big background issues are finalized in the adjudication, then we get to the contested cases. And the special master and the judge start teeing up individual cases and working through them. So they look at the watershed file report, they talk to the claimants, and they have what's called status conferences with the claimants, and they say, looks like you're missing a document here, you need to file this, or you need to assign the water right because your predecessor in interest owned it and you haven't assigned it to your name. They kind of put everything in order and then move forward. And the point of going through all the contested cases is that eventually the court will issue an abstract for your right. So the contested cases become these abstracts that go through all of the elements of a water right. You have the owner, the statement of claimant number, the legal basis of right, the purpose of use, the place of use, the priority date, the quantity. All of those things are in an abstract. And this is what this was what the final result of the adjudication looks like. This is a complete water right. And it goes into this water rights catalog. And this is a snapshot of the water rights catalog you can find on the Department of Water Resources website, and you can click through it. It's all publicly available. So these are the water rights that already have an abstract. And then once you have an abstract for all of the water rights in the adjudication, you get a final decree and you finally close that basin. We don't know when that will be for any of the watersheds in Arizona. It's going to be a long time, but essentially the final decree is just all of those abstracts stacked in chronological order, and that's it. And then that's the final decree. So then someone can say, I'm not getting my water and I have a 1920 priority date, and there's someone with a 1950 priority date I need to turn off. And then they have a book, essentially, of all of the water rights that exist in Arizona, and then you can administer the prior appropriation regime. Arizona is not the only one that goes through this very lengthy process. Pretty much all the Western states with prior appropriation rights have to go through some kind of big general stream adjudication. So this is Idaho. Idaho kind of famously finished their Snake River Basin adjudication, which is that kind of gray-blue area that's most of the state. And Justice Scalia came out and congratulated them when they did it because it's a really big deal to finalize some part of an adjudication. But they still have a number of watersheds that are under adjudication. Wyoming has general stream adjudications. Montana has general stream adjudications. Colorado has general stream adjudications. Oregon has general stream adjudications. So lots of other states have to go through this process. Different states do it a little differently. Sometimes it's more administrative, and it's kind of run by folks like Department of Water Resources, and the agency is just working through the claims. Sometimes it's more judicial. Arizona has this hybrid approach where we have both. So you file a claim with Department of Water Resources, but then it gets teed up before the court, and the court ultimately issues the abstract and the decree. So for the second part here, I'm just going to talk through some of the major issues in the adjudications. I'm going to talk about subflow, which is a really big issue, talk about some of the status of what's coming next in the adjudications, and then go through some of the major pending cases. So subflow is the idea that if you have a well that's close enough to the stream, you are actually pumping surface water and you need a surface water right. It's been really hard for people to understand because it's not intuitive. First of all, you have a well and you think groundwater, and that just makes sense. Also, we're still figuring out how to map out subflow zones. So if you are in a subflow zone today, you need a surface water right, and that's already true, but you might not quite understand that you're in a subflow zone because there isn't a map yet. And part of this is that this doesn't really make sense. Just scientifically, hydrologically, this is not really how water works. So this was the first big case for Arizona that started this whole subflow issue. This is Southwest Cotton. Essentially, there was a well and water rights from a stream, and they were saying the well was taking water rights out of the stream, and the court came and said, yes, it's true, the well can pump surface water, and said that subflow is those waters which slowly find their way through the sand and gravel constituting the bed of the stream, or lands under or immediately adjacent to the stream, and are themselves part of the surface stream. Which, if you're in 1931 and you have a well, it doesn't tell you a lot about whether or not you are in the subflow zone or not. And something that I like to tell students is that kind of around this time, a couple of years earlier, but it was still being cited in cases, there were cases that were coming out about groundwater that said, because the existence, origin, movement, and course of such waters and the causes which govern and direct their movements are so secret, occult, and concealed, an attempt to administer any set of legal rules in respect to them would be involved in hopeless uncertainties and would therefore be practically impossible. So this was an era where we did not know a lot about groundwater and how it worked. So it was really difficult to figure out what subflow really meant. And this has been the major issue in the adjudications. This is why we're 51 years in and we're just kind of really getting started with contested cases now, because there was a lot to work through. So decades of litigation later, what subflow eventually came to be is the saturated floodplain Holocene alluvium. So it's a hydrogeological concept here. So this is a picture of the floodplain Holocene alluvium. Saturated just means it's wet. So if you're in this alluvial area and you have a well, that means you are pumping water that impacts the surface stream. This is a really good way to help understand that. That inner valley area, if you say that's the subflow zone that's on either side of the stream, well A is directly in the subflow zone. Though at the lateral and vertical extent, it is pumping 100% subflow, and 100% of that water right has to come from surface water rights. So it needs a surface water right for that well. Well B shows that the well actually extends maybe below the subflow zone, but it's taking a lot of water from the subflow zone. So it's going to need mostly a surface water right. It's going to need a surface water right to cover whatever surface water it's pumping. Well C is outside the subflow zone, but that cone of depression is reaching into the subflow zone and taking water, so it too will need a surface water right. And this is called, what they're developing is called the cone of depression or jurisdictional test. That means if your cone of depression reaches into that subflow zone, you are under the jurisdiction of the adjudication court, you need a surface water right. Well D is pumping pure groundwater, so it does not need a surface water right. Like some of the other stuff we talk about, defining a subflow zone is a two-step process. First, Department of Water Resources issues a report on what it thinks the subflow zone should be based on the decades of cases that have come before. They use Thorson factors and go through, there's been a lot of litigation on this previously. So they use all of that and then do a very technical report on what the subflow zone should probably be. Then it goes to all of the parties in the adjudications. Everybody gets to object and talk through it. And then the court ultimately issues an order defining the boundaries. And once there's an order on the subflow zone, then it's finalized. So right now, this is a screenshot from DWR's website, a map of their subflow zones. We have 3 on here, but they're not 3 final subflow zones. So San Pedro is down south in the yellow. That one is a final subflow zone. That one's been fully determined. The Verde watershed has a subflow zone that is almost determined. I'm going to talk about that. And then the lower Little Colorado River, they just announced this about a week ago. They have ADWR issued its report on the subflow zone there, but it does not have a court order. And same with the Verde, there's not a final court order on the subflow zone. So those are not final yet, but it gives you a good idea of where you are in the subflow zone. So if you zoom in to this map, what you'll see is something like this, and there's just a colored area around the stream. So if your well is in that colored area, you are in the subflow zone, and you are presumed to be pumping subflow, which is surface water, and you need a surface water right. It is a rebuttable presumption, so if you can prove you're not pumping subflow, there was a case I worked on once that the water coming out of the well was hot, and it was very clearly from a different aquifer, and it was probably from a confined aquifer deep below the ground. They thought maybe this isn't part of the adjudication, and they were going to go look into it. But mostly, especially if you have a small domestic well, it's probably just in the subflow zone. So I'm going to go through the three current subflow zones that are out there. So the San Pedro subflow zone, they've defined the lateral boundaries of the subflow zone. They've looked at the vertical boundaries of the subflow zone. What they're doing right now, even though that's all defined, they're still working on it because they're working in that jurisdictional cone of depression test to figure out who outside the subflow zone is still subject to the adjudication court and needs to file a surface water claim. So they're developing a mod flow model to finalize that test. And this is a picture of kind of what the model does. It breaks down all the geological, hydrogeological layers in the San Pedro watershed, looks at how water moves and works, and then we'll come up with a model. Right now, there's a technical committee that's working on it with DWR. They've set a series of 6 meetings. The last will be on November 6th, 2025, and then they're going to meet back with the special master. And they're working on very technical stuff with this, like the structure of the model, review of recalibration targets, review of boundary conditions, recalibration, testing, and use. So these are the things that the technical committee is directed to work on. And how this model works practically, they've issued a kind of initial version of it is you run a program on your computer and you can type in your well number, and then it saves a file on your computer and you can open it up, and it says, basically tells you based on the data whether you are or are not pumping subflow. And then a separate file can tell you what percentage of subflow, how much subflow you're pumping, because you need a water right to cover that quantity of surface water. The Verde subflow zone, like I said, DWR issued initial reports previously. So we had 2021, the subflow delineation report for the main stem and Sycamore Canyon. In 2023, we had the remainder of the Verde watershed, but it's not finalized yet. There was a lot of objections over the subflow zone mapping, about whether or not DWR sufficiently mapped the extent of all the perennial or intermittent streams as determined under pre-development conditions, because that's how you look at the subflow zone. And then there was also discussion about revised mapping around some of the reservoirs up in Verde. So the special master has ordered DWR to go back and supplement its original report based on all these objections and discussions that happened, and DWR's supplemental report is due in December 15th, 2025, and then the special master will issue her order on the subflow zone, and then parties can object to that. And then the lower Little Colorado River, we just got the report out from DWR, so folks will have time to object to this report, and it'll go through the same process as the other subflow zones. And then the next steps in subflow are Silver Creek and the upper Little Colorado River. Silver Creek is at the bottom of the Little Colorado River Adjudication, kind of that little triangle-shaped thing in the red area. And then to the right of that triangle-shaped thing is the upper Little Colorado River. So the subflow zone report for Silver Creek is due in 2026, and the subflow zone report from DWR for the upper Little Colorado River is due in 2028. And if you look at all this and think, well, that's crazy, subflow doesn't make any sense, and that seems like it's taking a lot of time, pretty much everybody in the adjudications agrees. This is a quote from Judge Brain, who is the prior judge assigned to the adjudication, so it's now Judge Blaney, but Judge Brain rotated off. He said, this court's perception is that the law surrounding subflow has proven to be the root cause of the delay in the adjudications. That's why we're 51 years in. It's taken a long time to figure out how to manage subflow. The process is moving a lot quicker now that they've determined a lot of things in San Pedro and worked through a lot of the issues, and kind of that model will be applied to the other watersheds moving forward. And then another major issue here is just kind of the sequencing of what's next in the adjudications. The court held a conference in January to discuss this and then issued an order on kind of what's next with the adjudication. So that hydrographic survey report, that's kind of that big first step after folks file claims, is DWR goes out and looks at all the claims and reviews them and then make recommendations on what the water rights should be. So right now we have Verde is broken into five different HSRs that will come out. The first one is due out in 2027, so folks in Sycamore Canyon should definitely have their adjudication claims in before then. And then we have Lower Verde, Little Chino, and that should say Big Chino Wash. Little Chino Wash and Big Chino Wash are due out March 8th, 2030, and then Verde Canyon. And all the rest are, this is language from Department of Water Resources, beyond planning horizon. So 51 years in, we are speeding up, but it's still going to take a very long time. One thing that was also new from this order from the special master this past spring is that the Salt River Valley is going to have a separate HSR because Salt River project, and there's all those reservoirs up there, so it's kind of a different system. So that will have its own HSR. So when you look at Department of Water Resources website, they have maps of all the adjudicated areas, and it can get a little confusing because the hydrographic survey report boundaries are not necessarily watershed boundaries. They're kind of moving things around. And then last, I'm just going to cover some of the key issues that are pending in adjudication cases right now. So one thing with students that they're always surprised by, and some of the clients that I work with, is they might have a small domestic well and they appear in court, and the other parties to the case include the United States, several tribes, attorneys from major mines, attorneys from SRP, attorneys from major cities across the state. So anybody within a general stream adjudication who has a claim in that adjudication can object to anybody else in that adjudication. And all the major parties are involved in these cases because, partly because they filed objections back when these objections were really originally due back in the 1980s. And sometimes they had specific objections to the claims, but largely there might be broad objections, or they just kind of wanted to stay involved in these cases because in each contested case, something unique can happen and that can set law for the rest of the adjudication. So all the major parties are pretty much involved in every small case as well. So these are some of the individual contested cases that are moving forward where some issues have come up. So first is this case in the St. David Irrigation District case. There's an issue right now about whether pre-1919 rights are subject to statutory forfeiture. That's that 5 years of non-use. So right now, the prior special master said, yes, they are. Meaning if you had a pre-1919 water right and you didn't use it for 5 years between 1920 and 1925, after we had that statute enacted, you lost it and you no longer have a water right. So it's a lot to track the whole history of that pre-1919 water right. And another issue that's come out of the same case, there's a lot of issues in this case because it involves like 106 different points of diversion. So this will be on this list several times. Another issue that came out of that case is what is the level of proof that you have to show that you had pre-1919 water use. So you have to have significant proof, it looks like, to establish even that you had pre-1919 water use, not just that there was a homestead patent, not just that you were irrigating on that land at some point. You have to show where the irrigation was happening. And then if it is subject to pre-1919 forfeiture, you have to show over time that that irrigation continued. So it's a lot of historical research to work through all of that. Another major issue that's pending is the path to obtain a legal surface water right post-1919, in this case called Town of Huachuca City. The question in that case is the process set out in the 1919 Arizona Surface Water Code the exclusive method for a well owner to obtain an appropriative water right with a priority date after June 12, 1919? So essentially, is there another way for someone to get a water right if they didn't get a surface water right, but should have? Mostly because they were trying to comply with Arizona law, but didn't know that a subflow zone existed. So that case right now, they said, yes, you do have to get a surface water right. It doesn't matter if you didn't know you were in the subflow zone. That case has been appealed and is currently pending again. Another major issue is the evidence needed to prove a de minimis stock pond. For this one, A lot of folks have a stock pond claim, a de minimis stock pond claim. So that's talked a little bit about de minimis rights. There can be de minimis domestic and de minimis stock watering. And so if you have a smaller stock pond, then you might have a stock pond claim, a 38 form, but the 38 form at the bottom essentially gets certificated. And that's when you have a final certificated stock pond. And DWR hasn't processed all of them. There's thousands of stock ponds, and they only have so much time. And so there's a lot that haven't been finally certificated. And there's a question right now is, can you keep moving forward with some of these stock ponds in the adjudication if on that statement of claimant that we looked at, there's not an actual final water right, there's just a claim to a water right because it hasn't been certificated. So that's currently pending right now. There was also a question about the no injury rule and the process to change a point of diversion. Again, this is the St. David Irrigation District case. This is kind of a big issue, so I'm not going to talk too much about this, but essentially there's not really a way through our current regulations on how to change a point of diversion. There's a question of how that works in this case. And then finally, there's a big issue pending with the enforcement for decreed surface water rights. So the Gila River Indian community already has decreed rights. It wanted to enforce those rights against folks that don't necessarily have a final adjudicated water right. And there's a case about how that works because it is difficult because you can't really start administering a lot of this until you know how the whole system works. But it's taking a really long time. And in the meantime, water's being used. So there's a big question about how do you have enforcement now and how will we have enforcement when adjudications are final? And then I'll just end on this. This is a quote from a law review article that we often have students read. One does not get out of the Gila adjudication. It's a short sort of judicial black hole into which light, sound, lawyers, water, even Judge Goodfarb, indeed whole forests of paper will disappear. The only way out is the other end. And this is kind of ironic because this quote itself is about 20 years old at this point. So adjudications take a really long time. Some major issues have been worked out in the last decade or so, and things are kind of really picking up speed here. But there's still a long way to go. And I think with that, I will take questions.
All right. Well, thank you, Jennifer. That was really terrific. You might want to stop sharing so that we can see you a little bit better. That's great. And boy, you covered a lot and you didn't even get to tell us what your clinic is doing. So maybe there are some questions in the chat, but maybe I'd like to start with a question about what is the clinic that you direct? What is its role in this adjudications process?
Yeah, so we actually were created by a statute from the legislature because they said there's not enough folks to represent claimants in the adjudications. There's not enough water law attorneys in general. Where there are water law attorneys, they're often conflicted out because they're representing major parties and they're expensive. And these adjudications, like we saw, you have to appear in all kinds of cases and it takes a really long time. So that can be cost prohibitive for a lot of people. So they created us and they're allowing us to represent folks in the general stream adjudications up to the point of settlement. So we can appear in front of the special master and help settle claims. If somebody wants to go to trial, they get outside counsel. But we're here to just help work through the process and help folks kind of navigate this very complicated adjudication process. So people typically call us because they got a notice from the court and they don't know what's going on. Sometimes the court or the Department of Water Resources has sent them to us, or they just heard through neighbors and they said, they have an adjudication claim and I don't. Do I need one? And so we kind of do a full review of what legal water rights do you have right now? And then what water use are you currently using? And then what's that gap? And figure out, do we need to file something to cover all of your water use, or are you good? And a lot of folks have small wells and just don't know that they were in the subflow zone. That's a big part of our work.
And these are students who are enrolled in the clinic. Are they getting credit? Are they getting paid? Both?
They're getting credit, yeah. So we have a class component. We have class once a week, and we have a lot of guest speakers come through, or we'll do clinic rounds. And then most of their time, though, for the class, it's about 150 hours, 160 hours, has to come through client work. So they're taking on clients under my supervision. They're 39C certified, which is through the Arizona Supreme Court, so they can appear in court. So we had some of the first students ever appear in adjudication courts, and they can appear before the special master. We go out and visit clients and see the well and see how they're using water. And then We work through applications for permit, we fill all of that out, we work through adjudication claims, and just help kind of file everything that they need to file.
Well, that's great. That's great. Well, there are some questions, and one of the early ones that was put in early asked if you could speak at all to severing and transferring water rights.
Yeah, that's a separate process that you have to do. It's not through the adjudication court, but sever and transfer means you're severing the place of use of the water right and transferring it to a different place. And that's a process you have to apply for through the Department of Water Resources. So because water rights are attached to the land on which they started, you can't just move water use somewhere else. So you file an application for sever and transfer through the Department of Water Resources. They publicly notice it and make sure essentially that you're not going to harm other existing water users by moving that water use. And then you can move the place of use of that water if that application is approved. But if you don't do that and just move the water, you essentially started a new water right that's unpermitted. So you have to go through that process.
And is the department able to approve sever and transfers? Are those happening in these systems that are still in the adjudications court?
Yeah, they can approve even though there's not all the water rights aren't finalized. I mean, that is always an interesting question of how do you know that you're not going to harm anyone if we don't know who all of them are? So there is that question, but it gets publicly noticed. So basically anyone can come in and object and say, yes, that would harm my water right.
Okay. Also, Caitlin asked a question. This was at about the 1239 point. So sometimes the questions come in while you're speaking about why are there so many fewer water claims on the reservations in Arizona than the non-reservation areas?
Yeah, that's a good question too. So that's probably from that map that I showed of all the claims in the state. That's because the reservation has federal reserved water rights. So it's kind of like one giant claim. So that is a claim that the United States put forward on behalf of the tribes, and they work through that, but they don't show individual claims up there. It's kind of all one. And so that doesn't really appear on the statement of claimant map on the adjudications website.
Okay, and then a couple people, it's great. We appreciate this in the chat, and those of you who can remember, I sometimes forget. You might want to save the chat because sometimes people are putting in resources. Faith Shelton put in a link to the Arizona maps to find some of what you were talking about. I don't know that I'll pronounce Kichti's name properly, but that person is making an educational story map for understanding water systems and provided the link for that. Julia Fonseca put in a link about an article she's written about, and a number of people said, please send it to me and so forth. So there's been a really good exchange of some resources that has been going on. Dave Goodrich said, thank you for a great presentation. And he asked, isn't the dichotomy between Arizona and the federal view of surface groundwater interactions going to eventually lead to a legal collision of federal and state water rights?
So there's actually litigation about how so federal water rights we talked about they're different. So they kind of have a different process, even though they have to file them in state court. There's a lot of different rules to them. And there's already been litigation about do groundwater rights extend to federal reservations. And so they do get rights that can protect their groundwater as well through the adjudication process. So it's different than state law water rights. They do have to go through the state process, but that doesn't mean that state law applies to those federal water rights. They still get the federal law applied to them.
So great. I was just glancing through, there's a number of kudos and other things, but some questions that I'll still get to. We still have about 10 minutes here. But there is a question. There was a question earlier, which I answered that I believe we have your permission to post the slides, which we do as a PDF when we post the recording, which should be done by Thursday, maybe tomorrow, Wednesday, but certainly by Thursday. There is a question from Professor Martha Whitaker in the Hydrology and Atmospheric Sciences Department, if she would have permission to use some of your slides. I'm going to grab one of your slides myself, and I don't always ask permission. I give attribution. So I'm assuming, Jennifer, it's okay to use your slides with attribution?
Yes, absolutely. And Martha's students have already helped some of our adjudication clients. They've done some great work. So
Yeah.
yeah.
Yeah, and I will tell you the slide that I thought was very good. I'm giving a talk, as I mentioned in the intro, Thursday evening or late afternoon up in Phoenix, and I'm talking just very briefly. I just mentioned Indian water rights settlements. So that slide that you took from, it looks like two different slides from Robin Interpreter. I'll put both your names on that because
Yeah, and that's really all Robin. So that's, yeah, she did
yeah.
all that work.
Yeah, yeah. So that's great. So Martha, you've got the okay to use the slide or some of the slides. Aminta asked if you could please speak to the intersection between water adjudications, water allocations, and the current drought in Arizona. Now that's just a very small question, I think.
Yeah,
It's a big
no, I
question.
mean, that's a big question for a lot of people who are working in adjudications and who still need to file water rights and claims in the adjudications. Because, like I showed that list, a prior appropriation, you just make a list of all the water rights. We call those paper water rights. You can have an infinite list of people. You obviously don't have sufficient water to fill all of those water rights. But we're still making folks go through this pretty long judicial and administrative process because that's just what the process is in the West right now. But that doesn't mean that everybody gets water. So it can be pretty frustrating for a lot of people. And we also don't know how that's going to look because we need to define all the water rights before we can really understand what water there is to fill the water rights. So it's a difficult process to go through.
Yeah, and I see Martha says she wants to share the whole presentation. So that's
Absolutely.
on our website. Once we post it, Martha, you're welcome to use it. And we do appreciate our speakers giving us permission to do that. I regularly refer people to webinars that we've hosted. And again, many people have complimented you, Jennifer, on just how great and comprehensive a presentation you made. So really know that we all appreciate it. I'm scrolling through because some things are popping up again, so they're a little bit out of order. I had a question, and I'm going to get into the question. One question was, does your clinic help with de minimis claims?
We do. That's most of the folks that we work with are folks that have some kind of de minimis water right. We do have de minimis it's only defined in certain areas. And so there's probably people that we can work with that will likely have a de minimis claim. The difference is that when you have a de minimis claim is the determination through the adjudication court. So you have to have a water right. You might have a surface water certificate that says you use half an acre foot for domestic use. When it goes through the adjudication court, the quantity that they stamp on it is, if you're in San Pedro, no greater than 1 acre foot. And that's what gets just kind of routinely stamped. So they don't have to relitigate all of this and look at it again. But pretty much anyone with a smaller water use we'll work with.
Great. One question I had, and then there's a question about the cone of depression. How much abandonment of surface water rights goes on? I mean, do you see much of that?
I've had maybe one client where it looks like there was some abandonment, but that's not super typical. And abandonment normally comes into play if you have a really, really old water right. So something that goes back pre-1919. And so there might have been significant use at one time. Maybe there was a, historic dairy or ranching operation there. And then clearly it stopped at some point. And so maybe part of that water right was abandoned. But a lot of it right now is forfeiture instead of abandonment, especially because forfeiture starts 1919 at the latest right now. So that's typically what we're looking at for folks is those 5 years of non-use.
Yeah. So somebody asked about whether the cone of depression analysis will that potentially contribute to further delay similar to the subflow
Oh,
delay.
it has. Yes. Yeah. So the special master is really trying to move things forward. It was her idea. It's kind of a creative idea to have this working group. So she was kind of like, lawyers, you can attend this, but maybe please don't. And let's just have the technical folks who can actually do this work just get together and figure it out and work with the Department of Water Resources. So that's why there's that technical committee that's trying to work on that mod flow test right now. And the point is maybe with some of the lawyers gone, that can move forward a little quicker, and we can figure it out.
And, I recall hearing at times people talking about the numbers of staff people at the Department of Water Resources working on adjudications in these reports. Do you know the number, or maybe there's somebody listening can tell us, like, how many people at ADWR are working on this? It sounds like a tremendous amount of work that's required of them.
It is a lot of work. I don't know the number. It is interesting, if you have a well, you're talking to, there's a well section, you're also talking to surface water permitting, and then you're also talking to adjudication. So it's not just adjudications folks are working on the adjudication claims, but there's a surface water component to it, there's a well component to it. So you're working with different departments within the agency. I talk to generally the kind of similar same people every time. I know that there were massive funding cuts to DWR historically, and that's been an issue. I think they definitely do what they can and they do a great job, but the state could always give them more money.
Yeah, and it's been my understanding, very loosely obtained, that they have more staff than they did after some of those budget cuts
Yeah,
were
I
implemented,
believe so.
which is
Yeah.
great. Susanna of the Water Center asked the question again. This is an interesting, they're all interesting questions. What is the relationship? And I'll note that we're at 112, so this may be the last question. While you're answering, I'll scroll down to the very bottom, see what has come in most recently. But what is the relationship between adjudications in other states, such as Colorado, Wyoming, and the Colorado River?
Well, so the Colorado River is governed by the law of the Colorado River, which is that's encompasses a lot of things, but it means that you have a prior decree, it's agreements between states, it's case law, and it's actual water rights with the Bureau of Reclamation that have been defined through the federal government. So states aren't adjudicating the Colorado River. That's all this separate law of the Colorado River, and it's different. But then, yeah, so that's separate.
Okay. Well, I think I got to all the questions just in time. Again, many, many compliments. So if you want to save the chat and take a look at it, just about helping clarify understanding of so much and making things, somebody used the word, making something so complicated more palatable. And we really do appreciate it, Jennifer. We appreciate everybody who joined us today. And please keep up with our other webinars. And I wish everybody a great day. So thank you.
Thanks very much.